evidence, or there was other reasons for it. We can't make that same determination. You don't get the opportunity to review the jury's findings. And as such, it violates Hurst versus Florida.
Counsel, if we were to agree with you and try to determine what facts are enough for the purpose of supporting the presence of an aggravator under Poole, where would we look for that test? Where would we find guidance about the specificity required of a jury's factual finding in order for it to be sufficient under Poole?
Well, one of the things obviously is the jury must find beyond reasonable doubt the aggravator exists. What we don't know is what facts each of them rely upon. For example, there could be a stipulation by both parties to do a verdict form that is multiple choice. Did you find these facts? Did you find these facts? Did you find these facts? Beyond reasonable doubt. Then we can make a determination whether those facts rise to that level of beyond.
But that's my question. What's the limiting principle?
I don't know that there is any, only because we don't really get into the thought processes of the jury in their verdicts. We just want to know right now what facts they relied upon. If this court were to find that those facts are not substantial competent evidence, you can reverse that ruling. We need to know what the facts are. As far as what that level is concerned, you've never gotten into, and I'm not asking you to, get into the jury's deliberation process on that regard. Only the facts that they relied upon and whether they were found beyond reasonable doubt by all of them. That's all. As to issue 2, aggravated circumstance, this is a situation where this court might find, because of the number of aggravators, the one that was amended would amount to harmless error. But I don't think you can make that application, or at least got to review it, because there are different cases where, for example, Jackson, which was cited by the state, says that the 45-day rule doesn't apply when you have a situation where an arraignment was occurred years before. But that's not what we have here. What we have is a situation where the state had filed their notice early on in 2007, but then when the rule was changed based upon Hurst versus Florida, this case was sent back and they filed a notice of intent to seek the death penalty, and they tried to amend, adding a new aggravator. Well, even if the argument the state makes is correct, that it is not retroactive, it doesn't necessarily mean that. It has to be, because it became a new case with regard to the notice being filed. Now, I would assume the legislature, when they made the statute and the ruling by this court for following that same language, that there must be a notice of seeking the death penalty within 45 days, would also not apply the arraignment issue because it's already happened. However, there was an out for everybody on that situation. What the statute did and this rule did said, you can amend based upon showing of good cause. And in the Chantalupe case, which I've cited, is extremely intuitive as to, or instructive as to, how it works under all types of circumstances regarding the extension of time. The court had the authority to extend the time of the 45 days. The court had the authority to listen to good cause as to why they wanted to amend that rule. And the reason why I say it would not be a harmless error is because if you look at the first time this case went to trial, it did not have Hack in it, and the jury did not come back with a unanimous verdict. This time with Hack, they did come back with a unanimous verdict. The court actually took the exact same position as the state did and said that because it's not retroactive, therefore it doesn't. They don't have to put in that they were what the aggravators were, or the fact that they could amend. Well, look at the situation what the court's saying. If in fact that were true, that it's not retroactive, or they don't have to put the notice of intent to seek death penalty because of the arraignment, that would mean, even though the new rule is created, a case comes back and say in the first place, they didn't list the aggravators based on the old rule. That court is saying, you don't have to list the aggravators. You're not entitled to them because the rule is not retroactive. However, I'm suggesting that the rule was changed to give the state the opportunity to say, oh, it's good cause because the arraignment's already happened. We'll list the aggravators now, even though it's after arraignment, and you can extend that time. So my point being is, because Hack in this particular case should have been not approved by the court because of the fact that they didn't show good cause, which in Cantalupe, the court made the same finding. The court said, even though the court was wrong about the extension of the time frames, the court had the right to ask the the state to give a good cause for the purposes of the change. And they didn't. So he upheld the court's denial of that change. And I think this court should do the same here. I'd like to go to sufficient, issue 4, sufficient aggravators. I am kind of in a quandary myself because with regard to this court in Poole indicating that sufficiency means one aggravator is sufficient. Well, that becomes somewhat redundant because the statute specifically points out what is necessary to find the death penalty. One is they specifically state in the statute that one aggravator makes the person eligible for the death penalty. Then it goes on to say that the jury must find what is sufficient aggravators. This court says sufficient is one aggravator. Well, that's redundant. It doesn't make sense. The jury, I can't argue that the legislature would have put that in there, indicate to mean that both statements are the same. Not only that, with regard to sufficient aggravators, this court on many occasions has indicated what aggravators are weightier than others, and that goes to the sufficiency. For example, although the law indicates one aggravator is sufficient or eligible to constitute a person eligible for the death penalty, the jury might not. For example, aggravated, violent aggravating factor. What if somebody was convicted of a second battery, which now becomes a felony? A juror may find that, well, yeah, legally that may be an aggravator, but I don't believe it's sufficient. We don't know that because we don't get to hear the arguments behind the jury. But now you're saying that it's, just because it exists, it's sufficient to be an aggravator to justify the death penalty under the law, which the jury may find that it's not. That's all I have. I'll reserve for the rebuttal.
Good morning, may it please the court. Doris Meacham on behalf of the staff of the state. I'd like to start with claim 1, which is the motion for interrogatory penalty phase verdict. The trial court denied the motion, and they specifically said that this court in May set forth a new verdict form, and that's what I'll use. I'm not going to deviate from that, which the Florida Supreme Court says shall be used unless there is a compelling reason to do so. And I don't see a compelling reason to do so. And the state would agree. There was no reason to use the interrogatory verdict forms that were supplied by defense counsel because they were confusing, they were misleading, and they were not a correct statement of the law. The jury instructions were in comport with the jury verdict form that was used in this case, and the trial court did not err in denying that motion. As for claim 2, the appellant was indicted on 2 counts of first-degree murder and was arraigned on that indictment on February 15, 2007. That was the triggering date for the notice, which was filed. And at that time, there was no requirement to file the aggravating factors. Defense counsel cites to Chantalupe to say that good cause needed to be shown in order to amend. However, Chantalupe is not a resentencing case. That was actually a case that came after the statute was enforced. And in that case, they did need to show a good cause. Again, the trial court in this case agreed with the state and said that the statute was not retroactive, so it was not necessary to amend the notice or even to file a new notice. In fact, the state filed a new notice listing the 4 original aggravators as a courtesy. As far as prejudice, they didn't really argue in their motion that they were prejudiced by adding the HAC aggravator. All they argued was that the procedure wasn't followed. And the state would add that there was no prejudice in this. The HAC aggravator relied on facts that were known to the defense from the first trial. They even stated in their motion that the state could not show good cause because they knew about the facts from the beginning. And furthermore, the new penalty phase commenced on August 26, 2019, 7 months after the amended notice was made. So they had plenty of time to prepare for this. So there was no prejudice. And again, there was no reason to have a good cause to amend. As for, don't believe he went into the victim impact statement, but that is allowed in front of the jury per statute. 921.147, the prosecution may introduce and argue victim impact evidence to the jury. As for the sufficiency, I believe counsel is confusing what is necessary to find someone eligible for the death penalty, and all that's required is a prior aggravator to be found beyond a reasonable doubt. The sufficiency in the weighing or whether or not they're going to be selected for the death penalty. And in this case, for him to reason that sufficient is a qualitative rather than a numerical is incorrect. And again, in this case, Mr. McKenzie had 9 prior felony convictions, and he does not meet the standard that he stated would be in conflict with finding him eligible for the death sentence. I believe in section 6, he went into whether or not there were sufficient aggravating circumstances in this case, and there were. He was convicted of the contemporaneous HAC, CCP, the pecuniary gain. Multiple reasons for the aggravators were used in order to find him guilty of the murder. And as far as the aggravators are concerned, there were plenty of aggravators to be used in this case. The last part of this, I don't believe he touched on. The trial court is the one that's responsible for doing the written findings. I know in the beginning he said, how are we supposed to know what the jury decided? Well, their job was to say yes or no, whether or not there was an aggravator, and they did. It's up to the trial court to make the written findings. We're not here to know what the jury deliberated. That is the jury deliberation. And although counsel says that's not what he's asking for this court to do, that is exactly what he's asking this court to do. And if there are no questions, the state would ask this court to affirm the death sentence that was imposed in the new penalty phase down below. Thank you.
Thank you, counsel. Rebuttal.
Yes, Judge, with regard, Justice Kennedy, regarding the issue 1 where the state said that I was trying to get this court to get into the jury's determination of deliberation. That's not accurate. Right now, I contend that the statute requiring what the judge does in his written order is in violation of Hurst. I mean, see, that hasn't changed. When they did change the statute regarding what the jury's findings were based upon Hurst, they did not change the ruling regarding what a judge is supposed to do. And as long as I realize that in the statute, it doesn't say that the judge is supposed to list facts. You know, it's supposed to make certain findings. Technically speaking, if the trial court followed the statute, all he had to do really was to say the aggravators outweigh the mitigator, and he's done. That follows the statute. But they don't. They put the facts in there that they found. The jury is the one who's supposed to be able to do that under Hurst. Right now, Florida is in violation of the law under the United States Constitution, under Florida versus Hurst, in violation of the Constitution. As to count 2, state says Chantalupe is not irrelevant to this case. Well, even though it was not specifically by this court, a new sentencing, it sets out the general rules specifically with regard to extensions, where it requires, if the extension is already past the time frame, you have to show justifiable negligence. If not, you have to show good cause, and that's up to the discretion of the court. So Chantalupe is an instructive case in this case with regard to issue 2. That's all I have. Thank you.
All right. We thank you both for your arguments in this case, and the court will now prepare to take up the second and final case on today's docket. case of Davidson versus the state. Counsel?
Thank you, Chief Justice, Your Honors. I'm Barbara Basharis. I'm here representing Donald Davidson. I don't anticipate using all the time the court has allotted, Your Honor, but I'd like to reserve 5 minutes to be safe for rebuttal. Thank you. Mr. Davidson is asking the court to reverse his death sentence. And in today's argument, I'm going to concentrate on the second argument that we briefed, which has to do with the treatment of mitigating evidence. There were other arguments that were made for the purposes of preservation that I'm not going to address this morning. The first thing I'd like to talk about is the rejection of the statutory mitigating factor that the defendant could not conform his conduct to the requirements of law. If you look at section 921.1417, where the mitigators are found, the factor that involves conforming your conduct to the requirements of law is set out in the disjunctive with the capacity to appreciate the criminality of one's conduct. And what happened in the trial court's order here is that because the trial court found evidence that Mr. Davidson appreciated the criminality of his conduct and particularly took steps to avoid immediate detection after the charged offenses, that he also could conform his conduct to the requirements of the law. And interpreting that factor, which is subpart F of the statute, in that way, ignores the fact that it is written in the disjunctive, that the legislature has provided for a situation like this, where somebody could appreciate the criminality of his or her conduct, but still at the moment that a crime was committed, be unable to conform that conduct to the requirements of law. The two parts of that test are simply not synonyms for each other. And if you look at some of the other mitigating circumstances, you see that in subpart D, there's a subpart that's written in the conjunctive. The defendant was an accomplice and his or her participation was relatively minor. So for that mitigator to apply, both parts of that phrase would have to be demonstrated. Here
Counsel,
we have.
I understand the argument from the statutory perspective. Isn't your problem here, though, that the specific conduct of the defendant in, for example, physically removing his GPS bracelet demonstrates not just awareness, but a positive decision on his part to subvert the law that sort of gives the lie to the idea that he didn't understand, for example, that there were likely consequences to his actions that by just doing nothing, by not taking a positive action, he would be exposed to?
Your Honor, the problem with that is that when one phrases it as, appreciating that there were consequences to what he did, you're really talking about appreciating the criminality of what he had done. And the record shows that during the approximately 5 hours that the defendant was at the victim's house between the time he arrived, when the victim was there alone, and when he left with her daughter, that he did begin to appreciate the criminality of what he had done. But that isn't dispositive of whether he was able to conform his conduct to the requirements of law at the time he went to the house and began the assault. I'm sorry, Your Honor, were you going to speak?
Yeah, but that's exactly my question. Isn't the positive decision, the action he took to remove the GPS bracelet, demonstrative not just of his knowledge of the wrongness of his actions, but a purposeful choice, an affirmative decision on his part not to conform himself or his actions to the law?
No, because that happened, Your Honor, several hours after the initial offense began. We don't have a good timeline.
So his position is that he later gained that.
Yes, and I think that's consistent with the statement that he gave police as soon as he was apprehended, but also consistent with the expert testimony about his brain function and the way that he would have been impeded in his impulse control on the day of the offenses. That we have a period of time that he was at the house, and for part of that time, he is the only person who knows what happened at the house. For part of that time, we have the account of the child victim after she came home from school. But what we do know is that there's a period of about 5 hours between when he arrived at the house, intended to sexually assault the first victim, and when he began taking those later steps to avoid detection or to try to get away from the house with the child victim. So there's a separation, a temporal separation, and I'm not saying that there would always have to be a temporal separation, but I'm saying here you have a separation between the point in time at which he was unable to control his behavior, to conform his behavior, and the point in time when he begins to take affirmative steps that show that he appreciates what he has done is wrong. And certainly those affirmative steps continued after that for several hours. He left at about 5 o'clock with the child victim. He drove around for a certain period of time. And again, the record shows that during that period, he became remorseful and decided to take her back home and let her go near where he had originally taken her from, near her house. And then he initially tried to drive away, drove to Georgia, and then turned around and drove back. His statement to police was that he was coming back to turn himself in because he knew what he had done was wrong. I believe the police stopped him before he did that, but I think it's uncontroverted in the record that he was apprehended without incident. So once he turned around and came back from Georgia, he didn't take further steps to avoid either detection or apprehension. So you have several hours there where yes, there are positive indicators that the defendant knew what he had done was wrong, that he felt remorseful, that he felt afraid, that he knew that he was going to be punished, probably severely, and took steps to try to avoid that. But that does not determine whether he could conform his conduct to the requirements of law when this whole tragic series of events began to unfold. And that's where we have the uncontroverted expert testimony from the neuropsychologist who evaluated the defendant, tested his cognitive functioning, performed numerous tests on him, reviewed extensive documentation about his history, and concluded not only that he was operating under an extreme mental or emotional disturbance, but also that at the time of the offense against Ms. Welsh, that he couldn't conform his conduct to the requirements of law. And that inability to conform was probably, in the expert opinion, exacerbated by cocaine use. We don't have forensic evidence of the cocaine use. We don't have any testing that was done. We have the defendant's statement that at about 10 o'clock on the morning of the events, he ingested some cocaine. And then at noon, which would have been immediately before going into the victim's house and beginning the initial assault, that he ingested the rest of the cocaine that he had. And so that when he first went there, he was strongly under the influence. And then as that wore off, I think that's consistent with his ability later in the day to start taking purposeful action, as you pointed out. But the two parts of that mitigator are still separate, and here the facts show that they are still separate. I know that there are cases where courts have basically held that because the defendant demonstrated an appreciation for the criminality of his conduct, he was able to conform his conduct to the requirements of law. And I would say that that's not only conflating those two parts of the test, but depending on the evidence in a particular case, it's not giving appropriate weight to evidence. And here we have uncontroverted evidence from the defense.
Counsel, let me ask you this, counsel. So what is the uncontroverted evidence? What's the source of that?
The defense expert, Dr. Wow. I'm not sure.
Is it just his testimony? Just that testimony?
which was supported by testimony
But
from two other.
was it just that expert's testimony?
It is the expert testimony, I would say, combined with the defendant's own statement.
Okay. Let me ask you this. What do you say to the trial court's finding that seems to discredit the expert's testimony with respect to the defendant's ability to conform his conduct to the requirements of the law being substantially impaired, where the trial court says that the expert never questioned the defendant about the crimes in this case, his feelings about the crimes in the case, or what he was feeling leading up to the crimes in this case?
I would point, Your Honor, to the expert's own response to that question under cross-examination, which was that he had the defendant's lengthy and very detailed confession. And that is also in the record. It goes on for pages and pages. And it describes the defendant's state of mind that morning. It describes as best as the defendant could remember when he was interviewed by police, what he had been thinking along the way. It describes his feelings about what he had done. And so I don't think the trial court gave appropriate weight to the fact that the expert, in addition to all of the other voluminous documentation he had and the testing that he did, that he also had that nearly contemporaneous statement from the defendant of what the defendant had been thinking and experiencing that morning. So, Your Honors, I would argue that this case should be treated more like the cases of Coday or Nyber, which were both cited in the briefs, which were cases that recognized that a defendant can appreciate the criminality of his or her conduct without being able to control it at a particular moment in time. And Nyber, in addition, recognized that it was error to reject unrefuted expert testimony from an expert in brain dysfunction. Justice Kennedy, I think the trial court's pointing to that fact that the expert didn't personally ask Mr. Davidson, what were you thinking when you were doing this, doesn't refute the expert's conclusion, which was explained at length and based on testing and review of the defendant's history as well as his statement. And so there's no real evidence in the record that refutes that expert testimony. Now, if we were talking separately about the ability to appreciate criminality of the conduct by itself, that might be different because there are pieces of evidence that we can point to that might refute that. But here, the expert's opinion about his ability to conform his conduct to the requirements of law was not refuted. And so it was error to reject that simply by combining it into that mitigator and treating it as one sort of one big inquiry. The other two experts who testified also provided information that supported the expert opinion on his ability to conform. Dr. Bigler, who testified about changes in the area of Mr. Davidson's brain involving regulating behavior, the areas of the brain that regulate behavior, and Dr. Gold, who testified about the extensive history of adverse childhood experiences that the defendant had experienced, including physical abuse, sexual abuse, physical neglect, emotional neglect, divorce or separation, abandonment by a father, and other factors, all of which are known, and Dr. Gold explained this in his testimony, to cause adverse effects to the developing brain. So when you have the fact that the expert's opinion on his ability to conform is supported by so much evidence, there was no state expert refuting that information about Mr. Davidson's impairment, then it was error for the judge to reject that mitigator. Regarding the second issue relating to mitigation is the assignment of little weight to a number of items of non-statutory mitigation. And the standard of review of this is a deferential one. It's abuse of discretion. The trial court has wide discretion to use in weighing evidence that's well established, and we're not challenging that that's the standard. But when you look at what the standard means, Among other things, it means an unreasonable use of that discretion. And the defendant's position here is that it's simply unreasonable to weigh certain things as heavily as others, given the unique set of facts and circumstances in this case. The state suggested that we're arguing that there has to be some mandate of comparing and weighing all of the different mitigators against each other. And I don't think that's the case, but the case law does require that weighing of the mitigators has to be based on the unique facts of the case. Code A, among other cases, is one of the cases that talks about that. And so the way that you give a proper account or a proper value to the unique circumstances of each case is by realizing that some mitigators are going to be worth more than others. Otherwise, you're not recognizing the uniqueness of that case. You're basically just saying, you know what, all of this is worth the same, and none of it is going to outweigh the aggravators. And that's what happened with a number of the mitigators here. We have mitigators having to do with abandonment, neglect, abusive surroundings that were given little weight. And when you look at the fact that other things that were given little weight were things like Mr. Davidson being able to control himself in court, that's where the unreasonableness comes in. It's simply unreasonable to look at the history that this defendant experienced, the conditions that he grew up in, the family dynamic that he grew up in, the sexually dysfunctional family history that he grew up in, and say, well, this is only as weighty as the fact that he was able to control himself and behave respectfully in court, several years later, when he'd been removed from that situation and been in a controlled prison environment for a lengthy period of time. So when you have an unreasonable use of discretion, that's an abuse of that discretion, and the factors in this case should be reweighed, at least the factors that were identified in the initial brief as relating to Mr. Davidson's history of abuse that were given little weight should be reweighed. If there are no other questions, Your Honor, I'll reserve my remaining time.
Thank you, counsel.
Thank you.
Counsel for the state.
Good morning. I'm Assistant Attorney General David Chappell, and I represent the state of Florida in this matter. Moving right to issue 2 to address opposing counsel's arguments, I think both Justice Coriel and Justice Kennedy accurately described the situation in this particular case as to the state of the law. I think at the outset, it's very important to remember that we are dealing with an abuse of discretion standard here, which is deferential to the trial court's findings. And this court has precedent going back several years that indicate that a trial court is permitted to reject finding a statutory mitigating circumstance if there is competent substantial evidence in the record that indicates that expert testimony is contradicted by that evidence. Here in this case, of the 3 experts that the defense put on to try to prove this particular statutory mitigating circumstance, only one of the experts actually opined that the defendant was suffering from some type of impulse control issue at the time that these crimes took place. Dr. Woe, as Justice Kennedy pointed out, did not specifically speak to the defendant about his thoughts and feelings at the time that the murder occurred, or even the subsequent sexual assault on the victim's daughter that had occurred. Importantly here, there is competent substantial evidence in the record that the defendant did have some type of a plan in place to further his criminal conduct. The facts of the case quite simply would lead one to conclude that, considering he went to the victim's home, proceeded to attempt to engage in sexual intercourse with her. When she refused his advances, he then strangled her and stabbed her in the neck repeatedly. At that point in time, he comes into the living room where the victim's daughter has just come home from school. He then proceeds to sexually assault the daughter until the son comes home. When the son comes home, he then lies to the son, tells him that his mother and his sister are over at a neighbor's house so that he can continue his sexual assault on the daughter. He removes his GPS monitor. He kidnaps the daughter. He takes the van that belonged to the victim, travels further down the road to continue to sexually assault the daughter. This is evidence that the defendant had a particular goal in mind that he wanted to accomplish. He took the steps necessary in order to allow him to complete his desires and his mission at that point in time. This is not a case where the defendant lacked any type of impulse control issue. He knew what he was doing. He had the capability to do that. And he took specific concrete steps in order to ensure that he would be able to achieve his desired goal. Accordingly, there was substantial competent evidence in the record that demonstrates not only did the defendant know that he was engaging in multiple felony offenses, but that he did so intentionally and willingly, and he would have been able to stop himself because specifically of the plan that he had in place. Moving to the next point that opposing counsel raises, she argues specifically that the trial court erred in assigning little weight to various non-statutory mitigating circumstances, specifically with respect to the defendant's upbringing. The way that her argument is crafted, she's essentially asking this court to create new law in which all trial courts would be required to evaluate mitigating circumstances against one another in every case to determine what would the appropriate level of weight would be. And that goes against decades of this court's precedent, which requires individualized orders where trial courts evaluate each individual mitigating circumstances on its own merits and assign weight to that particular mitigating circumstance. There is no further requirement under this court's precedent or under the law that would force a trial court to engage in such a process. And in fact, that process would be entirely unwieldy when you have cases where defendants are presenting courts with dozens, if not 100 or more mitigating circumstances that would require a trial court to apparently evaluate all of these mitigating circumstances in contrast with one another. Finally, although the trial court assigned little weight to some of the child upbringing non-statutory mitigating circumstances, the trial court did look at the child abuse allegations and the evidence of child abuse that the defendant suffered and assigned several of those factors some weight under the child abuse heading in the sentencing order. So the court clearly looked at each of the individual mitigating circumstances and assigned weight to them in accordance with the trial court's discretion. As a final point on this particular issue, although the court assigned little weight to some of these circumstances, there is no specific number that is assigned to a particular mitigating circumstance. So the opposing counsel seems to indicate that little weight means little weight across the board. However, there's no inclination here that the trial court thought that little weight to the defendant's behavior in the courtroom was the exact same as little weight to the childhood upbringing. And there's just no way to articulate that in a reasonable fashion to have courts engage in some type of mathematical process where they assign a specific numbered weight to each individual mitigating circumstance and what that would entail. If there are no questions from the court, the state just respectfully requests that this court uphold and affirm the defendant's conviction and death sentence in this case.
Thank you, counsel. We'll now hear rebuttal.
Thank you, Your Honor. As to the first point, the expert opinion on Mr. Davidson's ability to conform his conduct, I would just again urge the court to look at the timeline involved here and not to conflate the factors of appreciating the criminality of one's conduct with the ability to conform one's conduct. And we have examples, as I said, like Code and Nider, where a defendant was under the influence of numerous circumstances similar to the defendant here. I think in Nider there was intoxication. Here we have cocaine consumption, the different brain abnormalities that were established. And all of those go to the fact that the defendant lacked impulse control. The fact that after lacking impulse control, you can then take purposeful action is not mutually exclusive. and in fact is often a problem in and of itself. But lacking impulse control is the issue, the ability to conform conduct, not the ability to understand, I just did something horrible. And then regarding the second part of the mitigation argument, the weight assigned to the factors, I have to respectfully disagree with how the state is characterizing our argument. And I don't really understand how you can have a requirement that a court assign weight to mitigators, which is a well-established requirement in our case law, but not say that the words used to do that have some meaning. The review of these mitigators is difficult enough without having to agree that saying little weight here means something different than saying little weight here. And I think if words are to be given their normal meaning, then giving something little weight versus giving it some weight or giving it moderate weight or whatever terms the trial court assigns, those terms have to be interpreted consistently, meaning I'm not weighing this very much, or I'm weighing it some, or I'm weighing it a medium amount. So we're not asking for the court to make new law on how these mitigators are weighed, but we are saying, based on the court's precedent, that the mitigators have to be weighed in the context of each case and the facts proved in each case, that there has to then be some individualization of the weight that's given those mitigators. And if you're assigning the same weight to two such dramatically different mitigators as childhood abuse and the ability to behave respectfully in court, then you're not really performing that function. And that's where the harm in this error comes in, is because if you're not really performing that function, what you're doing is you're tipping the scale from the very beginning of the balancing. It would be perfectly possible, and I would agree would be in the court's discretion, to have a situation where you assigned heavy weight to mitigating factors, but still found that they were outweighed by equally or greater weighted aggravators. But to just look at mitigators across the board and classify a huge list of them as getting little weight when there's competent evidence of the history of abuse and dysfunction that was in this defendant's background, is an abuse of discretion and basically predetermines the outcome of that balancing before you even get to the final step. Evaluating a mitigator on its own merits doesn't mean evaluating it in a vacuum. The law is clear that the process of evaluating these mitigators is supposed to reflect the unique facts and circumstances of each case. And that's what the trial court's order, however detailed, did not do in this case. For those reasons, we ask that you reverse the death sentence. If there are no further questions, I'm finished. Thank you, Your Honors.
Thank you, counsel. We thank you both for your arguments in this case today. That is the final case on today's docket. And so this session of the Florida Supreme Court is now